So, good morning to everyone. Thank you for joining this conference. This is going to be a somewhat different type of conference. We're going to begin by playing a film showing a mother who has taken two children to New York, and then we're going to have a panel of distinguished speakers telling us about the legal issues that arise from the story that you will see. I'd like to express my profound thanks to the panel of speakers. Time is going to be tight, so it's going to be a fairly short introduction. Our speakers are Kim Lehal of RWK Goodman. Thank you for joining, Kim. Philippa Morgan of Lyons Davidson. Again, thank you, Philippa. Can I pay a special word of welcome, please, to Valentina Shaknes, who joins us from New York at an ungodly hour. There's a 5-hour time difference. Valentina specializes in this area of family law. She's a founding partner in her boutique family law firm, and she writes and speaks frequently on this subject. So thank you, Valentina, for joining us. And then we have three specialists from 3PB Chambers. We have Dorian Day, Laura Scott, and Gemma Chapman. A lot of work has been put into this conference by the panel, and I'm grateful to you all. If you have questions that you would like us to try and answer today, we're going to see if we can have a short question and answer session running for what may be no more than 10 minutes at the end of this conference. So if you could put any questions you have in the Q&A session section, that would be really helpful. We're now going to start the film, please. Thank you. Here's the film.
Where are you?
Zach, I'm in New York.
What? What do you mean you're in New York? I was at Heathrow waiting for you off the flight. What's going on?
Zach, this isn't easy, but we're not coming back. I'm staying with Mum.
What? You can't do that. You can't just say that. I was waiting for 2 hours. You can't just not turn up.
Zach, I'm not coming back, okay? You knew that I was coming here for a while. You agreed.
I agreed you should have some time out with your mum. Yes, but that doesn't mean you were going to stay there. Not with Martha and James anyway. Where is she?
What, Martha? She's with me, of course.
James, what?
Hang on. He's at Mum's. Zach, you knew that. You knew that after you hit me, after you took it way, way too far, that it was over. You knew that.
Angie, what about what you did? You remember, eh?
No, what I did? Oh, come on. And Martha, what effect do you think it had on her to see you like that? She was traumatized. She still is. And all those other times that you yelled at me and said so many horrible things. And James, like, what sort of a role model?
Rubbish, you know it is. And look, I'm not waiting here like this. You need to bring Martha and James back here. Get on a plane, Angie.
No, I'm not coming back, Zach. You need to listen to what I'm saying. You knew that I was coming here. And when I came here, you knew that we were over. Okay, we were finished. What did you think I was going to do?
Angie, we were going to work on it. I can't just...
No, look. We've settled here now. Zach, it's nice here. We're happy. 2 months with Mum and I can see things much clearer now. I know who I am.
It's
now.
Settled. It's Martha's 4th birthday next week. Have you even thought about that? At her party? What about James? He's 12. What does he say? Have you even asked?
Zach, listen to me. I'm not coming back, okay? We are not coming back. James is fine. We found a school. He likes it here. He wants to stay. We're not coming back.
You are. You're not doing this. Not to Martha, not to James, not to me. This is their home.
Only for the last 3 years. And what about the years before, when we lived here in the States? You knew that I only came to the UK because you insisted. I was never happy, Zach.
You're just making this all up, Angie.
No, I'm not. You know I never liked living in the UK, not after everything that my dad did to my mum when we lived in London.
You're just being selfish. This is all about you, not the kids. Do what you want to do, Angie, but you're not staying there with the kids.
Yes. Yes, Zach, I am. And anyway, what did you expect? Allow you to make me go to pieces again, hey? More therapy, more pills, more hospital.
Yeah, well, that's not my fault. You always messed up, Angie. Yeah, blame your parents for that one, not me.
All because you're such a controlling bastard. I'm not doing it, Zach. I'm not putting Martha through all of that again, or James. And what about social services? What will they do this time?
Just because you told them a pack of lies.
No, I didn't. You were the one that turned up at nursery drunk in your car, remember? They reported you, not me.
Yes, and then you told them the lies. What do you think was going to happen, Angie? That they would lap up your lies, treat you as a victim? Poor Angie. You're just an idiot.
Oh, Zach.
Never mind all of this. I'm coming on the first flight that I can get, and I'm bringing Martha and James back here to their home. We live here.
No. No, Zach. They live with me here. I'm the one that has always looked after them. You've been too busy up your own backside with your work, remember? And if you do come here, Zach, if you do, I'm going to Canada. I'll go and stay with my uncle in Calgary. He has a place, and do you know what? We can stay there for as long as we like.
That is the wonderful Carly Norris and Jacob Crossley, the actors playing Zach and Angie. Happy tale. And I thought that we should begin with looking at the aspects of the Hague Convention that arise. And Kim, can you help us, please, with that first of all, from Zach's perspective, the father's perspective? Over to you, Kim. Thank you.
Yes, of course. Thank you, Stephen. So when we're looking at this from Zach's perspective, this is a removal. So it's an outgoing case. So the litigation will happen in New York. But the articles that are engaged in order for Zach to bring his application under the 1980 Hague Convention are as follows. And what I'll do is I'll run through what those articles are, and then I'll talk a bit about how they apply to Zach and Angie's situation before then handing over to Valentina, who will walk everyone through how that 1980 Hague Convention will operate in New York. So turning to the articles, the first one that's engaged is Article 3, which basically says that the removal or retention of a child is considered wrongful where it is in breach of the right of custody of the left behind parent, and at the time of the removal or retention, the left behind parent was actually exercising which the children must have been habitually resident in the left behind country. Article 5 then goes on to define rights of custody, which are rights relating to the care of the person, of the child, and a right to determine the child's place of residence. And rights of access is the right to take a child for a limited period of time, for example, a holiday, to a place other than the child's place of habitual residence. Article 11 is applicable here because that requires the courts in New York to act expeditiously in proceedings for the return of the children. And then finally, Article 12 then mandates the immediate return of the children to their country of habitual residence where there has been a wrongful removal or retention and the application has been made within 12 months. So thinking about those and how they apply to Zach and Angie's situation, Zach would need to, in terms of establishing a claim of abduction, he would need to demonstrate, in accordance with those articles of the convention, that firstly, he has rights of custody. And that's what we would all know as English practitioners as parental responsibility. Secondly, he needs to establish that the children were habitually resident in England and Wales, and that they were living here. And in terms of our case law, he needs to establish that they are here, they have been here for a settled purpose, a settled intention, and there's a degree of integration in a social and family environment, which in my view, based on what we know from the scenario, he would be able to do. He would then need to show that there has been a wrongful removal, which is a clandestine abduction without his consent or knowledge, or there's been a wrongful retention, and that would be a retention after an agreed period of holiday. And in this case, it's clear that Martha and James have been wrongfully retained in the US after what appears on the facts of what we've been told to be an agreed period of holiday. And then finally, his application needs to be made within 12 months. And from what we know from the facts of this case, they've been in New York for 2 months. So on that basis, he's met the test, in my view, to make his application. And then Article 8 would permit him to apply to the English Central Authority, who we know as the International Child Abduction and Contact Unit in London. And he would need to make his application to them with supporting documents to prove that he is the father, he does have rights of custody, basically setting out the test that I've just explained in his application. And then the central authority here would send it to the central authority in New York. And then Valentina is now best placed to set out what would happen once the application lands in New York and what defences Angie can then run under Article 13.
Okay, thank you very much indeed, Kim. And Valentina, over to you on those 2 points, what happens in New York and also about the defences that Angie might run. Thank you.
Thank you so much, Stephen, for having me and allowing me to participate in this podcast.
Thank you for being here.
Even at this ungodly hour, such a pleasure. So once an application is transmitted to the U.S. Central Authorities, the Office of Children's Issues within the U.S. State Department will handle the application and will assist Zach with finding counsel to help bring a petition under the Hague Convention, including even at a reduced cost or pro bono, depending on Zach's financial circumstances. And I think it's important to note that unfortunately in the US, we don't have a parallel assistance for the quote unquote abducting parent. So that's only something available to the left behind parent. Once Zach retains counsel, that counsel will bring a petition and most likely an order to show cause to the court in the jurisdiction where the children are currently located. So in New York City, it's likely to be either the Southern District or the Eastern District of New York. And in the US, under our federal legislation, our state and federal courts have concurrent jurisdiction, meaning that Zach and his counsel will have a choice of bringing the application in a state or a federal court. And that application will typically, in addition to seeking a return of the children, will also ask for certain ancillary relief, as we call it, including a request that Angie surrender the children's passports to ensure that the children cannot be removed from the court's jurisdiction, and possibly also a request that explicitly Angie not remove the children from the court's jurisdiction to avoid the situation where Zach's having to chase all over the world potentially to bring the kids home. So once a petition is filed with the court, the lawyer for Zach will also assist with service on Angie. And once Angie is served, she will have the right to appear and explain why the children should not be returned. The defenses that I see she can potentially raise are, one, grave risk of harm, which is found in Article 13(1)(b) of the Convention, the well-settled defense, which is Article 12, and what's called the mature child objection under Article 13 of the Convention. So starting with the grave risk of harm defense, Article 13(1)(b) of the Convention says that the court is not required to return the children if doing so would expose them to a grave risk of physical or psychological harm or otherwise place the child in an intolerable situation. Under the law as it has evolved in the US, a lot of cases involving domestic violence arise in this context under this exception, and the courts are very clear that the risk must indeed be grave and the harm must be very serious or severe. There must be a propensity for violence and a pattern of abuse, meaning that an isolated incident is not sufficient to sustain the defense. The harm must be to the child and not to the parent, not to the mother, although the courts recognize that in certain situations, exposure to harm is sufficient. And in the US, this defense must be established by clear and convincing evidence, which is an elevated evidentiary standard. With respect to Article 12, the rule, the well-settled rule, really only applies if the child has been in the jurisdiction in the US for at least 1 year or longer, and the child or the children have now well settled into their new environment. The 1 year is a bright line rule, and here it does not seem likely that Angie would be able to meet it unless Zach waits for a long time to bring the petition, which does not seem to be likely. So I will not go into the specific factors that the court would use to analyze whether a child is well settled, because I think we're unlikely to meet the 1 year. And then the last defense is the mature child objection. And the convention does not set a particular age for the children. It really is meant to be a very fact-sensitive analysis that looks not only to the age of the child and the child's maturity, but also courts in the US will look to whether the children are unduly influenced, intentionally or not intentionally, by the abducting parent or by the left behind parents. So it's intended to be very fact specific. Given that here James is 12 years old and Angie says that James is really happy and does not want to go back, that could be a viable defense. We would need to explore that further.
Well, thank you very much indeed, and thank you for putting it so concisely. It's a massive subject, but Laura, I wonder if you could help us, please, as to what guidance there is about the application of those principles.
Of course, thanks so much, Stephen. So when we're looking at the guidance, it's really helpful to look at the HCCH Guides to Good Practice to see what that recommends and how they might be applicable to this case. The purpose of these guides, of which there's 6 or 7 now, is to try and create a consistent and uniform approach to the application of the convention by the contracting states. And those guides are available to download without cost. They're really useful documents. They set out clear guidance and provide a number of resources, including citations of many authorities. So Guide 4 is on enforcement. The emphasis there is on expediting proceedings and encouraging mediation. It encourages cross-border cooperation, including the use of judicial networks. The International Hague Network of Judges here in England and Wales, we have Lord Justice Moylan and Mr. Justice MacDonald, who've recently produced a fact sheet on protective measures, which I think we'll be hearing a bit more about later. Guide 5 is solely in relation to Article 13(1)(b), and that came about following an increase in the use of this defence. It sets out the principles that the court should apply, which Valentina's really helpfully already outlined. It provides that there should be a step-by-step analysis when looking at the grave risk of harm. And the guide states that actually the court should evaluate the evidence from the taking parent and look at the protective measures in the state of habitual residence when coming to a conclusion of whether the exception of grave risk of harm is established, which is quite different, I think, from one of the cases that Valentina is aware of, where the US court, in fact, didn't make that distinction. So here, again, we'll be hearing a bit more about protective measures from Valentina and Philippa, I think. But as I said, just last month, there was the fact sheet produced by Lord Justice Moylan and Mr. Justice MacDonald. That's really helpful. It's across just 11 pages, and it's a really comprehensive overview of the protective measures available in England and Wales. It provides the definition of domestic abuse here. It sets out recognition and enforcement, including mirror orders and recognition under the 1996 Convention. And it also outlines a safeguarding scheme here, including local authorities and police, and gives a number of examples of protective measures.
Thank you very much, Laura. And we're now going to introduce Philippa to the conference. Thank you, Philippa. Would Angie be forced to bring the children back, please, first of all, Philippa?
Thank you, Stephen. So, first of all, the purpose of the Hague Convention is to return children swiftly to their country of habitual residence for the court in that jurisdiction to make welfare decisions about them. So it's not to decide long-term arrangements of custody of the children at all. So the court is dealing with an application in relation to the return of the children, and the court won't force Angie to return to this jurisdiction. The court doesn't have jurisdiction to make an order forcing Angie to return, and the court will only be focusing on making an order in relation to the children in this case. So the court will assume that Angie will return with the children if a return order is made. But ultimately, it's a matter for Angie whether or not she does decide to return with the children. But if she indicates that she's not going to return with them if an order for return is made, this would need to be explored very carefully by the court. However, it's not an automatic defence under Article 13b of the Hague Convention to say that Angie wouldn't return with the children, and this would then expose the children to physical or psychological harm or otherwise place them in an intolerable situation. So in this case, Angie and the children have only been in New York for 2 months, and the starting point would therefore be that the court should make an order providing for the children's forthwith return to the country of their habitual residence, which is the jurisdiction of England and Wales, subject to any defences that Angie raises, and then also subject to any protective measures that ZAC may offer to smooth the return of the children to this jurisdiction. And I believe that Valentina will touch on how the US court looks at protective measures and how they are dealt with there in that jurisdiction.
Yes, thank you, Valentina. This is why it's so valuable to have you here, and why we're so grateful. What would actually happen in New York to once this is conveyed to the New York court?
So if Angie asserts the defenses I outlined, in the US, the court would likely hold a hearing with live testimony at which Angie and Zach and any other witnesses that either of them may be inclined to call will be testifying live and will be subject to cross-examination. And the court will make assessments and fact-finding, not only with respect to the facts and what did or didn't actually occur, but also to their respective credibility. Again, as I said, we don't really have enough information to opine on the mature child defense, but certainly with respect to the grave risk of harm, if I were representing Angie, given that the law is clear that isolated incidents of abuse are not sufficient to sustain the defense, it's really important to establish a pattern of harm. And Angie touches upon things like pills, therapy, hospital visits. She says that Zach is controlling. Social services have been involved. He's shown up drunk at the school. So there certainly seems to be a pattern that a good practitioner would really have to dig into. And in my own professional experience, it's unlikely that when there is physical abuse, it's only that. The physical abuse tends to be, in my experience, a culmination of a pattern of abuse that's emotional, psychological, financial, and all of that needs to be explored here. So if ultimately it is a very high burden, so if Angie is not able to establish the defense, the court would order the children to be returned. And as Philippa said, there is no necessarily presumption or expectation that she necessarily would follow the children. And that in and of itself, the same as in the UK, is not sufficient to sustain the defense. The court would look to, if Zach raises protective measures, the court would assess those measures. I think two important differences is that in the United States, we have signed but not ratified the 1996 convention. So the protective measures are not mandatory. And in fact, the Supreme Court of the United States recently ruled in the matter of Golan versus Sara that courts are not required to consider protective measures unless they are raised by the parents. And even then, it is very important to consider the actual enforceability and the actual protections of these measures. And in cases involving domestic violence, the Supreme Court recognized expressly that there may not be sufficient protections that can be put into place, in part because all of these protections are necessarily reliant on the parent who has caused this situation to then follow whatever protections are put into place. I think those are the key differences. And if I were representing Zach, I would work very closely with Philippa to develop a record and really prove to the court that there are real measures that can be put into place that would protect the children, that it would be safe for the children to return, and all of that would need to be shown to the court.
Really interesting that in New York you hear oral evidence.
Yes, absolutely. And the decision will be made not on the papers, but on live testimony. Some judges will allow what we call the direct testimony to be done by affidavit, but cross-examination is always live.
Yeah. And Philippa, how does that differ from what happens here? Do you have oral evidence?
Very rarely, in fact, in Hague cases in this jurisdiction. Usually it's dealt with on the papers. It's not normal for there to be oral evidence in an Article 13b case. Usually the courts may hear oral evidence if a consent or acquiescence defence is being run, but it's very rare. And judges in this jurisdiction usually will deal with the matter on the papers.
Yes, and therefore I suppose if you are dealing with a jurisdiction where matters are dealt with on oral evidence, it's very important to ensure that the evidence is produced. If you're going to put evidence before the court to substantiate a defence, you must get that evidence so that it is properly before the court and clearly before the court.
Absolutely, and that's so important where the court is just dealing with it on the papers, because more often than not, you don't have the opportunity to give oral evidence to the court. So it's really important that at the first opportunity, you consider all of the evidence that you may wish to bring before the court at an early stage.
Because all this happens very quickly, doesn't it? That's the other point. You can't hang around.
No, you can't. And the court doesn't really look kindly on numerous applications to produce further evidence during the course of the proceedings. So you've got to get your house in order right from the beginning of the case. And cases under the Hague Convention should be dealt with within 6 weeks from start to finish. That very rarely happens, but they are very fast moving.
Yeah, thank you. Valentina, I'm sure you would agree with that. It's essential, if you're going to do this, if you are going to run a defence, that you file evidence that is directed not to matters of general welfare necessarily, but to the specific defence you're trying to run.
Absolutely. And especially because in the US, we also have to prove this defense using clear and convincing evidence, which is a heightened evidentiary standard, somewhere between the typical civil cases, preponderance of the evidence, and the criminal standard beyond a reasonable doubt. The court really has to be clearly convinced that this has happened, and also that if the children are returned, there will be risk to them in the future. And because of that, as much of substantiating evidence that you can produce, it's very, very important. So any kind of collateral fact witnesses, hospital records, police records, anything that photos of injuries, anything we can get our hands on. And of course, given how expedited and how quickly these proceedings must take place, it's really critically important to work as fast as we can to collect all of the evidence and put it together in a persuasive, cohesive manner.
All the more reason to have expertise in this particular field so that you really do know what you're doing. And the other point that you have to be alert to, and I know, Valentina, you've spoken to about this before, is if you're going to start accepting undertakings, you need to be very sure whether that undertaking is going to be enforceable in the country where that undertaking is going to be relevant. So an undertaking in this country may not, in fact, have an effect in some other countries.
Absolutely. And I think the courts in the US are very mindful of the fact that once the parties and their children leave this court's jurisdiction, this court will not be able to enforce its orders. So meaning that whatever protections are put into place, once they leave New York and go back to London, this court can't do anything about that. So that's why it's very important for Zach to persuade the court that yes, those whatever undertakings or protective measures that will be ordered will be enforced in the US. And we recognize that there is always a gap between sort of the law as it exists on the books, the statutes, the rules, and how those rules are actually applied, right? So if you have an order of protection, how is it applied? How does the police respond? What does the court system look like? What does it take to enforce it? What are the penalties for enforcement, etc.? It's not enough to just say, well, there is a law that says you can apply for an order of protection and it's, routinely granted. You have to do a lot more work than that to persuade the court that this order of protection will actually protect.
Thank you very much indeed. Thank you, Valentina, and thank you, Philippa, for that. And so Gemma and Dorian, imagine the two children do come back. What then?
So looking at it from the basis that Angie's been liaising with her representatives in New York, I would hope that with the very clear advice that she would have been given, they would be making contact with some solicitors and representatives in the UK to try and pave her way if she is ordered, or if the children are ordered to return, and we assume that Angie will want to go with them, what she can do to make sure that in the UK she effectively hits the boards running. So what I would be looking at is making or having applications for non-molestation orders and occupation orders set to go upon touching base on UK soil. I would want to ensure that an application for an international relocation was set up, because where the Article 13B defence may fail under the Hague, what we may be able to do here with an international relocation application is to utilise the domestic abuse case law within the UK. And specifically, there is a very good judgment that I would bring to everybody's attention from Lord Justice Cobb from this year. It's Domestic Abuse International Relocation 2025 EWCA Civ 888. And whilst that wasn't a Hague case, the application was based on domestic abuse and the impact of the domestic abuse on the mother and on the children. And what Lord Justice Cobb said at paragraph 89 is that whilst we have relocation law that's very well settled in the UK, the law surrounding domestic abuse is evolving at pace. And it's a very good judgment looking at how you utilise Practice Direction 12J in the UK, looking at the nature of the allegations, the extent that they're relevant, and considering whether or not a fact-finding hearing would be necessary. So you could establish the factual matrix within the UK. You could then look at how you utilise that in your application for international relocation. So evidence that would hopefully have started to have been gathered as part of the US and the ideal of 6 weeks. You would have information from nursery, from when the father was turning up drunk. You would hopefully have information from the local authority. you can feed in the mature child defence, because with James at the age of 12, he's going to be able to communicate his wishes and feelings clearly. You will have a decision to make whether or not you swiftly try and bring on board an independent social worker to assess wishes and feelings. You would also look at, if there wasn't the affordability for that, you would then, depending on whether or not that those issues of domestic abuse were within the last, and the issues of the local authority being involved were in the last 6 months, you may be backed into a corner of getting a local authority to look at wishes and feelings in a report. My suggestion is, if there's the money to do it, always get an independent social worker. So you have, in essence, if any of the defences have failed to prevent the return of the child, you almost get a second bite of the cherry with the international relocation application that you can make, and a lot of the groundwork would have been done. My main concern representing Angie would be trying to get very far away from a narrative which says that she's made unilateral decisions, a unilateral decision to retain. So in presenting a package, it would be, we heard on the video that she's identified a school. No, Angie, give me a choice of 3, if possible, that we can give father the choice. So he is involved. I would want protective measures around the contact arrangements. Does he need supported contact at this point? And then I would be looking at presenting a well thought out and presented contact arrangement that could be enforced in the US. And that's when I would be looking back to the solicitors in the US and saying, Valentina, help me. What can we do with mirror orders? Where do we go from here? This is the package we've got. These are the protective measures we've got in the UK. How do those translate into US legislation?
Right, thank you. And Dorian, over to you on the same point. Thank you, Gemma.
Thank you, Stephen. Thank you, Gemma. Just to add up a few points to this, but also looking from Zach's point of view on this particular question, because of course, Zach will probably, as soon as the children are back in the UK, want to hold the position by some form of order that the children are not removed again, first of all. Secondly, he will be conducting proceedings by either his own application for a residence order or in opposition to an order if that is made by the mother. In that respect, he's going to be looking at a number of factors. Firstly, it's very interesting to hear from Valentina that the American court will have considered issues of credibility and in effect made findings, which is not the case in the UK court. The UK court in these cases will look out as to whether the criteria are met and the defences or otherwise are met. He will also be looking at how best well he can place his case for the children to be here and advancing his case, one would assume, for primary residence, or in the alternative, he would be looking at what child arrangements could be in place so that he has a good relationship with the children if the mother succeeds and can go back to the United States or indeed Canada. In that respect, it is important that he has a clearly defined judgment and an order which is in place so he can enforce any arrangements should it be the case that she decides again to remain in the United States and not comply with that. As Valentina has discussed, the 1996 Hague Convention is not formally recognized in the United States as such because it's not been ratified. There is an intention to follow it in that they are signatories, but it's not at the moment ratified. He would therefore be looking to the avenue of what is called the Uniform Child Custody and Enforcement Act in the United States. That is a provision that is routinely used between different states in the US, but also has a provision which will permit country orders from other countries to be enforced before the US court. His order would be registered with the local district court for where the children are resident, and then in that way, if the personal jurisdiction criteria were met, he would be able to bring his own proceedings and use the American enforcement techniques, which arguably are certainly as severe, and one may argue more severe than in England, where they have a felony which is created. There is the possibility of imprisonment, change of the custody arrangements, or financial penalties.
Thank you very much indeed, Dorian. And Kim, could I turn to you and Philippa? So what can Zach do in the United Kingdom? Zach comes through your door, the solicitor comes into your offices, either RWK Goodman or Lyons Davidson. What do you do? What can you do?
Well, first of all, he'd be advised to go to ICACU first and foremost. And really, ultimately, there's nothing else that I would advise him to do. He's got to run his Hague application, his return application in New York. The Hague Convention ultimately is about the courts determining jurisdiction. So which country has the jurisdiction to make the long-term welfare decisions about the children? And the country that's going to make that decision is the US. So the US will decide, is that going to be the US if the children stay in the US? Or actually, if they're going to be returned and the defences fail, it will be England that will make the decisions for child arrangements, relocation, non-molestation order, all those other applications that we would see under the Children Act, the Family Law Act, in terms of Zach wanting the children to live with him. All of that would need to be dealt with once the Hague application has been run. And I think Philippa is going to go into a bit more detail about that and how we would have run these cases historically and how things have changed somewhat since then.
Yes, so when Kim and I first started dealing with these international child abduction cases, which was many years ago now, if a child was wrongfully removed from this jurisdiction or wrongfully retained away from it, we would rush off to the urgent applications judge sitting at the Royal Courts of Justice, and we would seek an order making the child a ward of court, and we would effectively seek a summary return order, even if you were pursuing an outward application under the Hague Convention. However, the position now is very much that if you have an outward abduction and the country's signatory to the 1980 Hague Convention, your remedy, as Kim said, is to make an outgoing application through ICACU for the member state to deal with that application and not to make an application in this jurisdiction. So the exception to that would be if the country to where the children have been abducted is not signatory to the 1980 Hague Convention. Then in those circumstances, you would make an application to the court in this jurisdiction. But that is a whole other topic for another day. Now, the exceptions to not making an application to the court here, if the country is signatory to the Hague Convention, is if there are exceptional circumstances. So, for example, if there are genuine welfare concerns, and there's a very good reason to have parallel proceedings, or, for example, if the member states are very slow at dealing with Hague Convention applications and a delay wouldn't be in the child's best interests, but you would have to argue that it was reasonable to take a twin approach, and it may well depend on which High Court judge you appear before as to whether or not you get anywhere with that application. So we've dealt with a case recently, in fact, involving Romania, who are signatory to the Hague Convention. And we were trying to get legal aid to seek counsel's opinion on the success of a dual application on the basis that the authorities in Romania are historically slow at dealing with applications under the Hague Convention. The mother and father in that case had links to criminal activity, and there was an ongoing criminal investigation involving her family in Romania. So we tried to distinguish on the facts of the case, and that in an authority of res, the court said that such applications can be justified providing there are exceptional circumstances which may be met, and that it's open for the court to clarify the correct approach to be taken post-Brexit, where Brussels 2 no longer applies. However, the legal aid agency refused our application for funding, so that case didn't get off the ground. But it is quite an interesting point. However, in this case, I would not be advising Zach to rush off to make any sort of application to the court in this jurisdiction, because he would be dealing with an outward Hague Convention application, and the USA are well equipped to deal with an application under the Hague Convention, and it's highly unlikely that in the circumstances of this case, the court here would make any sort of summary determination.
Thank you, Philippa. And Valentina, imagine Zach says, right, I'm jumping on a plane, I'm coming to New York, I'm going to sort it out myself. What happens?
Well, I think a potential concern could be that by doing so, Zach is, somehow acquiescing to the children remaining in New York. And of course, under Article 13A of the Hague Convention, consent or acquiescence are a defense, right? The court is not required to return if the left behind parent has consented to the children being removed or retained outside of the state of habitual residence. Consent and acquiescence, although they're often sort of lumped together, are separate defenses. Consent looks to the period before the removal or retention, and acquiescence is what happens after the removal or retention. And it's a very fact-specific analysis. But for acquiescence to be found, there has to be a certain degree of formality. So I think even though it could be a concern, unless Zach says something like, well, maybe it's okay if the children stay there for some time while you and I work things out, right? Or send a text message or an email. There has to be a degree of formality to his quote unquote acquiescence. Short of that, if Zach just hops on the plane and comes and says, Angie, come on, we can work this out. Let's not do this to the kids. I think it's very unlikely that the court would find he has in fact acquiesced merely by coming to New York to try and urge her to return and avoid, a protracted legal battle.
Yeah, thank you. Again, how important it is to get proper advice about people who really can give advice about these specific issues that arise. Acquiescence is something that needs detailed, careful consideration, at least. And so, finally, Kim and Philippa, in the few minutes there are, imagine Angie does go off to Canada, and 4 months later, this all blows up. What difference would that make, please? And if we can just deal with it very succinctly, please.
Absolutely. If we look at the timeline, we know that the children have been in New York for approximately 2 months. If they go to Canada from there, the timeline then skips to 4 months. And then 4 months after that takes us to 10 months. So we're still within the 12-month window in terms of making an application. So Zach could make his application for a return to Canada then. Canada are signatory to the 1980 Hague Convention. And he could run his Hague application from there.
Philippa, anything else you'd like to say about Canada?
Yes, so
if
if I were acting for Angie and she had then wrongfully retained in Canada and Zach had made an application, I would consider whether or not the children had acquired habitual residence in Canada. And the issue of habitual residence is a question of fact, and it's not a legal concept such as domicile. So there's no legal rule whereby a child automatically takes the domicile of his parents. So habitual residence is a very complex legal issue, and we could probably spend the whole hour talking about that. But there would need to be a real consideration of whether or not these children were habitually resident in Canada. And the sort of things that you would consider was how long they had been there, the reasons for the parents' move, the place and conditions of attendance at the children's school if they were at school there, the family and social relationship that the child has, whether any possessions were brought, and also the requisite degree of integration. And the relevant question is whether the children have achieved some degree of integration in a social and family environment. So it's not necessary for the children to be fully integrated before gaining habitual residence. So in this case, because they've only been in Canada for 4 months, that's probably not sufficient time to gain habitual residence, taking all of the factors into account. And I don't think that would preclude the court from making an order for return, subject to any other defences that Angie may be raising.
Thank you. And I'm not sure if we have Andy Hayher, King's Counsel from Calgary in Canada, attending, but having listened to him previously, he's reminded us of two Canadian decisions about habitual residence. One is the Office of the Children's Lawyer in Balev, B-A-L-E-V, 2018 Supreme Court of Canada decisions at page 16. And also a case of Ludwig and Ludwig, which was decided in the Ontario Court of Appeal, which is their two authorities, I hope still on habitual residence. But thank you very much. Well, that completes the prepared questions, but we've had some other questions that have been sent in. Thank you for those. And can I ask one of them straight away, please? What if Zach doesn't have PR? What if he hasn't got parental responsibility? Kim, and does that make any difference? And I'd like to bring Valentina and Philippa again in on this, if you could, please.
It does change things somewhat, because if we look at the articles that I started with, one of the articles clearly states that he must have rights of custody at the time of the wrongful removal or retention. So if he doesn't have them, his application could fail. And even if he did try to run it, I'm sure Valentina will be able to explain what would happen in terms of Angie defending, but he must have rights of custody at the time. So he could go and make an application for parental responsibility, but it would be questionable because he has to have them at the time that the children have actually been removed or retained.
Valentina, is it going to make a difference in New York?
So in the US, under the law as it's applied here, custodial rights are interpreted very broadly. One certainly must not have, it's not necessary to have, sole custody or sole parental responsibility, as you would call it. Simply having the rights of access. If the court has determined that, for example, Zach can have the children every other weekend or something, that would be sufficient for him to have custodial rights, and Angie removing the children from the UK, those rights would be violated. So, any custodial rights really would be sufficient to sustain a petition. It does not need to be primary custody.
Okay, fine. Thank you. Philippa, would you like, or Dorian or anybody else, would you like to add to that at all?
I suppose if there's another scenario where Zach didn't have parental responsibility, but before the wrongful removal or retention took place, he had made an application to the English court for parental responsibility. If Angie then subsequently wrongfully retained in the children, Zach could potentially argue that the court in this jurisdiction had the necessary rights of custody, and he could make an application for the children's return and rely on that.
Okay, fine, thank you. There's another question that's come in, and that is, would dual nationality make a difference? Because these two kids may well have dual nationality, bearing in mind what we've heard.
I think as far as the application for summary return is concerned, I do not think it will make any difference whatsoever. It may have consequences in terms of immigration movements, but as far as the summary return to England is concerned, I don't think it'll impact at all.
Thank you. There's another question that has been asked in a number of different ways, and that is, what about non-Hague Convention countries? And Kim, can I ask you, please, raise completely different considerations, does it not? And not only general considerations, but you need to deal with a specific country that is concerned.
Absolutely. I mean, non-Hague Convention countries, it's a totally different process. It's a totally different test. It's a conference in itself. And it also depends on whether it's an incoming abduction or an outgoing, or whether there's what we would say a stranded spouse in a non-Hague country. So I think that in itself can be quite complicated, but it's an entirely different process to the 1980 Hague Convention.
And Gemma, thank you. In the minute we've got left, Angie comes through your door, says to you, I'm thinking of taking the kids off to America to stay there. What would have been the advice to her? Should she have done it, or would it have been better for her to stay here and sort it out here first?
Would always say, don't take a unilateral decision. Would always say, let's get the application together, let's gather the evidence, and then present a well-argued and well set out plan for an international relocation.
Yeah. So don't do it is the best advice you can give. Sort it out first before you
Correct.
think before you leave. Okay, that's fine. So thank you very much indeed to our panelists. You've given up lots of your time to prepare this conference. These things don't just happen. And Valentina, you've given up a load of sleep as well. But I hope everyone has found it helpful. At one point, we're up to 412 people attending, so it's gone out to a huge audience. And so I hope the panelists feel that their hard work has been worthwhile. I'm sure it has. So we will now call this conference to an end. Thank you for attending it.